Hi everybody and welcome to the Essex Public International Law Lecture Series. My name is Dr. Emily Jones and I am the co-convener along with my colleague Dr. Megan Wong of this series. It's my pleasure to be your host for this evening and we're very pleased to have with us today, as you can see on your screen, Lucía Solano, who is Colombian career diplomat and head of treaties section in the Colombian Ministry of Foreign Affairs. And she's joining us today for our first fireside chat of the series, so it's also very exciting on that front. And this is not only our first fireside chat, but it's also our first International Law of the Sea event, which Dr. Wong and I are particularly excited about. The law of the sea, like many areas of international law, is usually pretty male dominated. This is changing. There are now several women who sit as members of ITLOS, which is truly fantastic and a fact that Dr. Wong and I find to be very inspiring. But I'm particularly proud this evening to be hosting a Law of the Sea fireside chat between two really fantastic women who are both phenomenal Law of the Sea experts. So you're in for a treat. I will hand over to Dr. Wong shortly to introduce our speaker this evening. But before I do so, I want to just say a few words about the series and about Essex. So the Essex Public International Law Lecture Series is co-founded and co-convened by myself and Dr. Megan Wong. We are both international lawyers, but Dr. Wong is a formalist and I am a critical international legal scholar. So this series is really built on our friendship and our deep respect for one another's scholarship. The idea behind the series was really to bring these kind of complementary but very different skills together. So the series therefore prides itself on building on these two important intellectual traditions of international law, formalism and international legal practice and critical international legal theory. So some of you will have joined us for previous events and some of you may be new, but you will have hopefully seen that we have some great speakers lined up and have already had some great speakers over the past few weeks, including internationally renowned academics, practitioners and judges. We do hope that you'll also join us for our future events. So speakers that we have coming up this term include Professor Marty Koskinemi, Judge Kitty Chasseri of ITLOS, Professor Hilary Charlesworth and Professor Campbell McLaughlin QC. So I would now like to take the opportunity to introduce you to Dr. Wong. Dr. Megan Wong is a lecturer at the University of Essex and is currently the director for the LLM in International Law degree. And she also directs the LLM in International Law of the Sea module, which she co-teaches with our colleague, Dr. Antonio Coco. So the topic of today's inaugural lecture falls very much within the expertise of Dr. Wong, as I already mentioned. So she's a generalist international lawyer, but she has a particular interest in the law of the sea. Dr. Wong has published on canonical topics of international law and has advised states on a broad set of issues such as the law of treaties, international institutional law, jurisdiction, and the relationship between international and domestic law. She holds a PhD from the University of Leiden, an LLM in Public International Law from the University College London, and was called to the Bar of England and Wales. Dr. Wong is also the author of a forthcoming monograph, which is coming out with Cambridge University Press, entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. So there's my introduction for you all, and I would now like to hand over to Dr. Wong, who will introduce Lucia. Thank you.
Thank you, Dr. Jones, for the kind introduction. So good evening, good afternoon, good morning, depending on where in the world you are joining us from. This is indeed our first International Law of the Sea event in our lecture series, as well as our first fireside chat. So thank you for joining us. I'm very pleased to introduce our speaker. Lucía Solano is a Colombian career diplomat, international lawyer, and head of the Treaty Office of the International Law Directorate at the Colombian Ministry of Foreign Affairs. She is also a member of Colombia's legal team in the cases its country faces before the International Court of Justice, which focus on the law of the sea and maritime law matters. She advises her government on maritime affairs. Her diplomatic career has brought her to The Hague between 2013 and 2018, where she was legal advisor in the Colombian embassy in The Hague. Lucía Solano holds an LLM from Georgetown University Law Center, Washington, D.C., and she delivers lectures in international law, diplomatic and consular law, and the law of the sea regularly. We're also very proud that she is a guest speaker for our Law of Treaties class in our LLM in Public International Law module, which is also taught by Dr. Jones and me. So before I start, let me just set out some housekeeping rules. So I will be chairing this fireside chat with Lucia. I will be asking the questions, but there will be time after for Q&A. If you would like to ask your question, type out your question in the Q&A box and feel free to list your affiliations. I will read out your name and your affiliations unless you click anonymous. So there will be a chance for you to participate in this session as well. So let's begin our fireside chat, and let me start by saying, hi Lucia, great to have you here today, welcome. Let's start by perhaps could you tell us about the geopolitics of Colombia within Latin America and the Caribbean?
Hola, hello everyone. Thank you, Dr. Jones and Dr. Wong, for such a beautiful and kind introduction. I think I should begin by saying, how grateful I am to be here this afternoon, by congratulating the two of you for organizing this series, which is really amazing. I feel honored to be among the list of amazing speakers that you have been inviting to these lectures, and I will invite everyone to RSVP for the coming lectures, which are all great as well. It's again an absolute honor to be here today with you. I guess to get into the matter, I should start by placing Colombia on the map. Colombia is located in the northernmost part of South America. We have coasts in the Pacific Ocean and the Caribbean Sea, and we have entered into 10 or so maritime delimitation agreements with our neighbors. Although we have not yet delimited our maritime boundaries with Venezuela, which is our largest maritime boundary. And unfortunately, we have tried several times in the past, and we actually at points we have reached some agreements, but they have not been able to get approved by Congress either in Caracas or in Bogota. So right now it doesn't look like it's a good moment to enter into negotiations for a new agreement. However, we can't lose hope. Maybe at some point in the near future we'll manage to get into an agreement. The other situation everybody knows is our relation with Nicaragua. We have some open matters there. We have 2 pending cases before the ICJ, which are waiting for the court to set the dates for hearings on the merits. Hopefully that will happen very soon, and we will have judgments also in the coming months, probably in a year or so. We'll see. Both cases are very much related to law of the sea and maritime law and even delimitation matters. So I will invite everybody to follow and to stay tuned, because they will be they are very interesting, and the hearings will be very interesting as well. I think other than that, we are good. That said, though, that is the case for most Latin American states. Everybody has most of their boundaries already settled. Most of the times by negotiation, most of the times by agreements reached among the states, but sometimes we have resorted to adjudication. Actually, out of 12 or 13 cases that the ICJ has had on maritime delimitation, 6 have been from Latin American states, including the Peru-Chile case, or the Colombia-Nicaragua first case, the several cases between Nicaragua and Costa Rica, and also all the Honduras, Nicaragua, El Salvador cases. I think this shows that perhaps, or for some people it might say or show that perhaps negotiation and diplomacy have failed among Latin American states sometimes, and we have needed to resort to negotiation. But I guess that a more optimistic view of the thing is to say that Latin American states in general believe in the dispute settlement system set by the UN Charter first, and also, and perhaps more in a broader perspective, we believe in international law. We care about international law, and even if we have discrepancies, we resort to adjudication when negotiation doesn't work.
Thank you, Lucia. Let me just follow up from that. As you point out about the growing number of judgments from the International Court of Justice concerning maritime delimitations, in the Caribbean and the Pacific Ocean between Latin American states. Do you think that there is a sufficiently developed body of jurisprudence regarding maritime delimitation? And if I could also follow up to ask, do government officials such as yourself consider that there is a consistency in these judgments, taking into account the geographical peculiarities of this region, and perhaps more broadly speaking, what is the effect of these judgments on the geopolitics of the region when it comes to the negotiation of maritime delimitation agreements?
All great questions. Thank you, Dr. Wong, for putting those. As I said before, Latin American states have resorted to adjudication when negotiations have not been successful. This is evidently possible due to the fact that we have entered into agreements that confer jurisdiction to the court, more likely to the ICJ, sometimes to other international courts and tribunals. But in general, if one reviews all the cases on maritime delimitation, the jurisprudence has evolved into what I think one can call a fairly settled area of the law. We all know, for example, by heart, the three-step approach that the ICJ or ITLOS applies on maritime delimitation, for example. And I think that states can sort of try to anticipate how the courts will reason in a given case. So at least we try. Obviously, the particular circumstances of each delimitation can have and will have an effect on the result. Or matters, for example, such as if you are in an enclosed or semi-enclosed sea, might also have an effect, and a state can be somehow surprised by the outcome of a litigation. But in general, I think that maritime delimitation is sort of an area that it's more or less settled. Also, states in general can always have questions or reactions or concerns about certain decisions of international courts and tribunals. But I think also that in general, in the law of the sea, and in particular in the law of maritime delimitation, there are areas that are in constant evolution. So even if the jurisprudence is quite settled, it will continue to evolve. And these bodies of law are affected and will continue to be affected by matters such as, for example, climate change or sea level rise. And even environmental issues can affect maritime delimitations at some point. So I think, or even more specifically, at least for the case of Colombia, matters such as the continental shelf beyond 200 nautical miles from the coast, and that interplay between law and more technical matters can, at some point have an effect on future jurisprudence of the court. So we'll see what the court has to say, the courts have to say in the future about these topics. I also think that Latin American states have been quite instrumental, as I said before, in contributing to this area of the law. We will continue to do so, actually, because, for example, in the current docket of the court, 4 cases are from Latin American states and related to maritime law or maritime delimitation matters. So we will continue to have a say, at least, on these things. Now, again, as I said before, states react differently, and some tensions can even remain after a judgment is issued, for example. But in all cases, and we all do this, like states study the jurisprudence, we read the cases, we establish similarities and differences among the cases that the courts have dealt with. So we all do that, and every state in Latin America does that too. So you know the jurisprudence, you prepare or sort of prepare your people for what can happen, but then sometimes the judgments are surprising. One last point I think I should probably point out is that Latin American states, beyond their bilateral controversies which exist, I think they are genuinely concerned about the protection and the orderly management of oceans and seas, and about the resources too. And when it is necessary, we find ways to negotiate as a region. So for example, during the BBNJ negotiations currently taking place, we have negotiated as a joint region. We have tried to reach agreements, even if we have differences among us, or even if we have different approaches, for example, to the law of the sea convention. Some states are parties to it, some states are not, and regardless of those differences, we still manage to negotiate together. So I think that's something that's probably important to point out.
Thank you, Lucia, for setting the scene for us and giving us so much insight into the geopolitics and the importance of negotiating maritime delimitation agreements. Shall we get into the details of the negotiating process? What can you tell us about the process and share with us from your experience?
Sure, I think perhaps let me start by saying that the limitation of maritime boundaries by agreement remains the main or the primary rule in international law, in application, obviously, of the general principle of peaceful settlement of international disputes. And in doing so, the negotiating process is very significant for achieving equitable results. It is estimated that half of the world's maritime boundaries are still pending delimitation. I don't know if that number is still accurate, but it's probably quite close to that. Some others point out that there, we still need about 100 maritime bilateral agreements on maritime boundaries to be negotiated. And again, I don't know if the number is accurate, but it's probably very close to that. So understanding how to negotiate these agreements, it is important and will continue to be important for states in the future, but also for practitioners in the area. It's going to be a great source of work, if not, at the very least. And particularly for government officials, it is important because we are the ones in the end that negotiate these agreements on behalf of our states. So there can be differences about how states approach these processes, but in general, everybody does more or less the same or follow more or less the same steps. So first, you obviously need to know if there's a need to delimit. You either acknowledge that there are potential overlapping claims between two or more states, and either with adjacent or opposite coasts, and you see the need to settle those. Or the need to delimit can also come from an outside source. For example, the oil industry can be putting some pressure on the state, or even fishermen or commercial fisheries. So the need comes or can come from very different sources. But once you establish there's a need to enter into a limitation agreement, it is important to examine the overall situation. And this involves checking, the sensitivities that are there, the political situation, the bilateral relationship, even the needs of the local communities, if they are interested in having the area delimited or not, and many considerations, including from different perspectives like legal, geographic, economic, political, historical, and so on. Afterwards, you conduct all the preparatory work, which is a lot, and it's going to take a lot of time, so states have to be ready for that. You require, or you take also all the necessary studies. For example, you engage the technical experts, you acquire software and all the technical equipment, you gather data, you assess financial implications, you get official documents, you check your archives. For example, in the case of Colombia, some of our official archives are not in Colombia, so you have to go, I don't know, to Washington, D.C., to the Library of Congress of the US, which sometimes holds very important historical documentation. So all of those things have been taken into account. And you do what you should have done from the beginning, which is check the jurisprudence, check your own maritime delimitation agreements, and see what you can gather from that. And then you need to reach a negotiating position, and that's perhaps the most sensitive moment of the process so far. And you have to reach a position that is comprehensive, that is consistent, and evidently that comes from senior officials in your government, even from the most senior government officials and presidents and so on, and from policymakers as well. And then you set up the team, which is quite an important part, and probably for people hearing us today, it's interesting to know how states set up their teams. And then, since these agreements on maritime delimitation involve so many aspects, you do not only need jurists, which are basic for the case, but you also need to involve technical experts. You need your hydrographers, your cartographers, your geographers, and many other experts in your team. You normally have your Navy involved, your Ministry of Defense, for example, and you need a political line. So again, you have to involve senior leadership within your government. You might have to involve other colleagues from the Ministries of Foreign Affairs, like people who are experts in the state with which you are negotiating. In the case of Colombia, the team would probably be led by somebody from my office, or probably the first meeting is going to be headed by the Minister of Foreign Affairs, but afterwards the next meetings are probably going to be handled by our office. So we have to have a solid team, and definitely not just one person. You need quite a lot of lawyers. You also might need to involve law firms or outside counsel if you don't have all the legal expertise within your own government officials, and that's going to have a significant impact on the financial budget. And on the other hand, that's also a very important consideration, all of those financial matters, because if you have all the expertise and all the resources and all the negotiation is going to be handled within the government's budget, that's one thing. But when you have to involve experts coming from abroad, things are going to get pricier. Another important thing is also to engage as many experts as you can, and sometimes they are within your government, but sometimes, and most of the times in Latin America, they are not within your government. So that's very important to bear in mind, because it's going to affect your budget importantly. I mean, if I could choose, I guess I would have a all Colombian team, but that's impossible for us. And at the same time, you do want to have people with different perspectives in your team, so you kind of check your positions, that you're sure that you're making the best you can, that you're putting the best negotiating position that you can reach. So states definitely and frequently engage external advisors and law firms and things like that. But the head of the delegation is still going to be a government official. So it has to be led by government officials. Going back to the groundwork, I guess you have to then conduct as many preparatory meetings as you can, and then you finally begin talks with the other state on the start of the negotiations, on the date, on how many meetings you're going to have, on confidentiality, for example, which might be extremely important, or whether you're going to have press coverage or not. And you have to set a good atmosphere, and finally you have to issue full powers, for example, if the head of the team is going to need those, and you finally start the negotiations.
Thank you, Lucia, for telling us about the negotiation process. I'm wondering, could you tell us, what are the interests of states when they negotiate maritime boundary agreements? And if I could also follow up from what you were saying earlier about Latin America having common themes, could you tell us whether there's a common theme within the Latin American region when it comes to negotiating maritime boundary agreements?
Yes, for sure. Thank you for that question. I think that with so many words, boundaries still pending delimitation, this is a very important issue for every state, or for most states at the very least. And certainly states want to have good neighborly relations and are in general concerned about peaceful management of the seas and the oceans, and in a more broader sense, I guess. But sometimes states are thinking about entering into agreements that, besides setting a boundary line, can also include provisions, for example, on cooperation in matters of common concern, which might be particular to a geographical location or even to a bilateral factual complex. But I would say that states in general worry about the same things, or about common things. In Latin America, as I said before, when I was telling you about that example at the BBNJ negotiations, we certainly have differences among us, but I think that we're concerned about the same things everybody is concerned. And perhaps the most significant one is on cooperating, on trying to do things together and to exploit the resources if we you know, need them, and to, in general, we do care about having our, you know, boundaries delimited, but also about having, you know, not having issues in that regard, about having relations that can lead to better, in general, quite better relations among us. So I think it's not very different from other areas of the world. So I wouldn't consider many specific cases for Latin America or many specific considerations, but in general we care about, you know, the orderly and management of the seas as everybody else does.
Thank you. Let's now come to practical details. Could you tell us, say, about the content of maritime delimitation agreements?
Great, I would love to. The first thing I think I have to say is that, as a general rule, maritime boundary delimitation agreements tend to be quite simple, quite short, quite straightforward. And it might surprise some, but most of the agreements have 3 to 15 articles. No, they are no longer than that. Especially considering, you know, how long and how difficult it is to reach the agreements and how long the process is. It's quite surprising that they are quite so short most of the times. However, you know, state practice has evidenced several more complex situations, which in turn have resulted in complex agreements. For example, the agreement between Argentina and Uruguay on the Rio de la Plata from 1973 has 92 articles, which is quite like the longest one. And then you have the treaty between Australia and Indonesia from 1989, which has 34 articles, which is not a lot, but it has 4 annexes, and those annexes are fairly heavy. But then you have cases like the Esguerra-Bárcenas Treaty, which is the agreement between Nicaragua and Nicaragua and Colombia, which has led to many decades of litigation among us. And that agreement has 2 articles. So just 2 articles have created quite a havoc. But I mean, it's questionable whether the Esguerra-Bárcenas Treaty is a maritime delimitation treaty, but it does have led to a lot of discussions on maritime delimitation. Generally, the agreements start, as any treaty, with a preamble, then you have your usual definitions, and then you include all those clauses particularly relating to the actual delimitation line. The establishment of the line usually starts by both states agreeing on what is the geographical area concerned and determining the zones of sovereignty of each state. Then the following articles commonly contain a small number of other provisions concerning the starting point of the line of delimitation, its course, the different points through which it passes. They are usually established by reference to coordinates of latitude and longitude, and the nature of the line joining the different points, so you can have straight baselines, for example, the line's termination point, and the geodetic data. It may also be necessary to append technical annexes or maps or charts if that's needed, if the states see the need for that. Most agreements then contain the provisions devoted to particular problems, for example, such as the entitlements of islands and rocks or low tide elevations. And they can also refer to navigation and navigational rights, overflight, recognizing the right of passage, safety and security of navigation, and so on. So depending on the factual complex, you sort of include more and more clauses or very specific clauses that relate to a specific situation that you want to regulate through the agreement. Also, and since the delimitation line is normally established by a list of coordinates, there may be a need to specify the method to determine the actual location of the points, as well as who will perform the task. For example, in the case between Panama and Colombia of 1976, we created like a special commission to sort of identify those points. And then the agreements can also contain provisions regarding third states, like when they refer to a point where the line would meet the outer limit of a maritime zone of a third state, which is commonly referred to as a tree point. After, the agreements normally contain dispute settlement provisions, as most treaties, In the case of Latin America, usually they refer to the ICJ, but that's not necessarily the case in other areas of the world. And some may also contain cooperative arrangement clauses, like establishing a joint regime area if states want to, and that is, for example, the case of the treaty between Colombia and Jamaica of 1993. And then they end with the usual final clauses of any treaty, on the depositary, on the entry into force, on the language, on the date, and then the signatures of the representatives of each state.
Thanks, Lucia. What about telling us more about what kinds of circumstances states consider relevant for delimitation? And if I could ask you, how does this compare with the criteria that international courts and tribunals apply?
Well, during the negotiation, states raise all sorts of considerations which they deem important for a delimitation. So after the classic path of identifying the relevant coasts and the relevant areas and considering the coastal geography, states start by drawing different sets of lines, and they always begin with the strict equidistance line, and then they bring up all sorts of factors which might call for an adjustment of the line, and then afterwards they confirm that the line thus adjusted would not lead to an inequitable result, sort of the same way international courts and tribunals do. The difference, however, is that states, when sort of addressing the proportionality of the line and taking into account, so many things that states want to bring to the table, they enter into discussions on many other matters that would probably not be raised before an international court, because the courts would probably not get into that. So when reviewing any factor to adjust the lines, states present many interests that they would not present in an international court or tribunal. For example, they can invoke geological and geomorphological factors, such as the physical and geological structure of the continental shelf areas involved, or they can refer to economic and social factors, and that can be of incredible importance. And states, for example, can mention the size or the location of the natural resources, such as an oil deposit or a fishery resource, or the existence, for example, of a marine protected area or any other environmental consideration. States could also refer to the conduct of the authorities for the establishment of maritime boundaries, such as statements that the authorities have issued, or assurances that senior officials have expressed. So states bring those to the table. They can also refer to security and political considerations, which are also very, very important for states, and states will probably not bring or not raise in the same way before an international tribunal. And they can also refer to interests of third states in the delimitation area, which may be relevant in the maritime delimitation for the assessment of the equitableness of a delimitation line, for example. Historic titles can also play a very important role, and they certainly do in Latin American states. But I would say that historic title is something you bring earlier in the negotiation, like before drawing the line, you have already brought that up. And probably it's a very important consideration for deciding whether to enter in a negotiation or not. So you bring it up much earlier in the process. And then states sometimes can be concerned about the interests of their nationals and the local communities located in the area. Sometimes the lines are so far, away from the coast that there are no specific communities affected, but in some other cases you have islands there, or you have specific situations that demand that the local communities are taken into account. But if I have to be honest, none of these factors usually are reflected in writing in the agreements. So states do bring them to the table, states do raise those, and they want those to be taken into account when adjusting the line. But in most of the cases, the agreements do not have a specific provision on any of these issues. What happens more frequently is that states then enter into other sorts of agreements that can address these particular concerns, maybe, but that's also not as frequent. And also that states can find ways to cooperate beyond the actual delimitation line. So I would say that when you are going to draft the agreement, you probably notice that most of those agreements, even if you have so many considerations in mind, in the end, they just refer to the line and how to set the line, and that's it. So I would say that what is clear, though, is that, as noted by the ICJ in the 1969 North Sea case, there is no legal limits to what states, what the considerations that states can take into account for the purpose of making sure that they apply equitable procedures and that they reach equitable agreements. So states bring all sorts of things to the table, but then the agreement is going to be much shorter in the end.
Thank you, Lucia. Could I ask, is it easy for states to renegotiate existing agreements, and what are the broader domestic ramifications of?
That is a very difficult question, particularly for Colombia, but I'll try to address it as well as I can. So it really depends on the domestic laws of the states concerned and what they establish, right? But states, of course, it's always possible to renegotiate agreements or complement them, or states can enter into complementary agreements to the initial one, or they can enter into other sort of instruments, that they can be hard law instruments or even soft law, non-binding instruments. But some domestic regulations can make things harder, and that is the case of Colombia. So again, I'm trying to be here as sensitive to the Colombian situation as possible. But we have a quite important difficulty, because in the case of Colombia, any agreement on maritime boundaries, or on limits, actually, it's not just maritime limits, modifies the constitution. So we cannot just enter into an agreement and do the usual process of ratifying it, but we have to amend the constitution, which has as a consequence makes it very, very hard to renegotiate any agreement, and makes it very hard in practice to apply any other way of setting up a maritime boundary. So as everybody is aware, that has led to some complications with our neighbors, and has put us in a very difficult position internationally. And I think everybody knows what I'm talking about. But it's definitely a conundrum if you are an official of the government. It's really difficult to figure out what to do sometimes, with that dichotomy. And we really haven't quite figured out what to do. But I mean, it does show that Colombia is quite an interesting country, and we have these special legal challenges, but at the same time, if anybody hearing to us has any creative ideas, by all means share them with us.
Thanks, Lucia. Let me just follow up and ask a different kind of question, but probably similar theme. To what extent nowadays can we see a trend that negotiating states think more about alternative arrangements? So it's not just about creating lines, so to speak, but actually investing in proper cooperation efforts so as to properly explore and exploit resources in a cooperative framework.
I think that states can be very imaginative when they negotiate these agreements. And if some of those maritime boundary agreements are already in place, they can still negotiate related agreements. They can still negotiate even soft law instruments. So if states want to cooperate, they'll find a way. From my experience in the treaty office, the most common areas for cooperation are usually maritime interdiction, or matters related to cooperation among the navies, or even fishing or fisheries crime. Beyond that, the fight in general against transnational organized crime, or environmental matters, such as, for example, the protection of sensitive areas like coral reefs. Another relevant thing that perhaps states want to cooperate about, and has become more and more common, is topics such as climate change and sea level rise. So states are thinking about adaptation measures to be taken jointly, or at finding other ways to face the changes and the challenges that matters like I don't know, ocean acidification and related things can bring to them. So states are beginning to sort of have some discussions about that and how cooperation can be a way forward. Another relevant thing to have in mind is that maritime boundary delimitation can arguably be viewed as an essential sort of precursor to the full realization of the resource potential or of a national maritime zone. So with regard, for example, to seabed resources, it could prove crucial to the well-being and to the political stability sometimes of states to agree on those boundaries and to start, exploring and exploiting the resources. So sometimes these agreements are really extremely significant for states. But again, since states have no limits on the sorts of areas on which they can cooperate, they have so many options available, and I think the future will bring many creative sort of agreements.
Thank you, Lucia. And why don't we end our fireside chat by looking forward? How, in your view, can states improve their practice in negotiating maritime delimitation agreements?
Oh, wow, that is a very important question and a very nice way to end the fireside chat. I think that although seemingly technical and even sometimes boring, these agreements are really at the heart of the interests of states, and because in the end the lines will determine the extent of the rights and obligations of states within their side of the line. And here perhaps it is important to point out that states see maritime delimitation agreements in general as a way to establish which are their rights or up to where they have rights. But it's also important to bear in mind that they have obligations too. So it's not just about the rights that arise out of a treaty, but also the things that they are supposed to be doing after reaching the agreement. So perhaps it has to change a little bit that view. Also, I think that this area of international law is an area where diplomats and government officials have quite a lot of work to do. Unlike in other areas where we just sort of speak and that's it, here we can make an important difference if we are well prepared, if we are ready to negotiate these agreements on behalf of our states. But also I think states have to identify the need or pertinence of involving other actors and outside advisors. I'm not saying I'm against that at all, but I'm saying that maybe we should start, by we I mean states, we should start by identifying what we have or what kind of expertise we need, and then deciding on hiring outside counsel. And we have to be better at assessing our needs. I think that diplomats and government officials are very bad at saying we don't know about this or we are not well trained on this area. And we don't have to do it alone. I mean, on a day-to-day basis, we usually have quite a lot of work, so we're not thinking about the future, how to improve, or where we are lacking expertise, or where we need training, for example. So you can always engage outside, people who do this, who do the assessment for you. And I think states, considering how many maritime delimitations are still needed, I think states should be thinking about that already, about training their people, about assessing their needs, about getting outside help to identify those needs. I mean, I'm pleased to say that Colombia has quite a lot of lawyers, right? We have quite a lot of law schools, we have quite a lot of postgraduate degrees in international law in several universities, and even postgraduate degrees in the law of the sea. I think that it's the only one or one of the very few in Latin America. But that's okay, of course, but I think that's not enough. We still hire foreign advisors, and again, I said that I think that's fine. But those advisors have to sort of leave some of the knowledge in Colombia, so they should have a responsibility to share what they know with, in the case of Colombia, with Colombians, and not just sort of leave with the knowledge when the relationship ends. So I think it is important to sort of work on that too. And Then on the way to reach the agreements, particularly if states, I think that there have been some developments. The case, for example, of Australia and Timor-Leste, it's quite an inspiration for all states. So you don't have to choose between entering into agreements, and if you cannot manage to agree, then you have to go to adjudication. There are some middle ways that states can draw inspiration from. And the last thing I will say, and I can't help but mention it, is that frequently I see myself as the only one, or the one of the very few women on the negotiating table, or even in litigation, or worse, on litigation perhaps. And I think there are many women who are knowledgeable about these areas of the law, less perhaps than in other areas of international law. So I think we have to do quite an important job to attract more women to this quite very interesting but quite manly dominated area of the law. Even if, for example, if we were to negotiate an agreement tomorrow, in the case of Colombia, well, the Minister of Foreign Affairs is Colombia, it's a woman, the legal advisor is a woman, I am a woman, but that's just momentary, and we'll see if that changes in the future. So I think as just having this fireside chat led by women and organized by women, it's a good source of inspiration. Perhaps in the future we can organize one on how to involve more women in the law of the sea. But I guess what I would say to end is that we have to think about how to have more women join us in this area of the law. And that's it.
Thank you, Lucia. And now we come to the Q&A session. We don't have too much time, so apologies in advance for those of you who have typed in your questions, and we don't have enough time to go through everything. But I would like to start with a question from Irini Papanikolaopoulos from the University of Milano Bicocca. And Irini thanks you for your very interesting presentation, and she wants to know, based on your experience, would you consider that more innovative solutions such as joint zones, for example, work well in practice, or in the end, is it better to go for a traditional or possibly single line and all-purpose maritime boundary?
I think that depends a lot on the factual complex. It depends a lot on your specific situation. And in some cases, if states have good relations in general, they can find ways to cooperate. So I gave the example of Colombia and Jamaica having a joint regime area, which has worked perfectly well throughout the years. So the area basically is an area in which we share the resources, and everybody's happy with that, right? But in some other situations, in some other bilateral relations, that's not so easy. Cooperation, it's harder. So in those cases, just reaching an agreement is a huge accomplishment. So when the bilateral relationship doesn't allow for a more cooperative sort of way of dealing with things, it's going to be very much more difficult to agree on a more creative way of setting up a boundary, but or of cooperating or working together. But when things are well, cooperation is great. When things are not so well, it can lead to more complications. So it really depends on the bilateral situation, or what's going on the ground.
Thank you, Lucia. I would like to ask a question from, this question comes from Brian McGarry, who is circling back to my question about common themes in Latin American practice. Brian wonders if you could speak to the role that regional trends in delimitation methodology may play in affecting bilateral negotiations, specifically the Latin American agreements based on parallels of latitude, such as Colombia, Ecuador, 1975. How might the use of this method, which one neighbor prejudice a coastal state's negotiating position when treaty making with its other neighbor?
I think that is really a great question. In general, Latin American states that are quite advanced and creative in the law of the sea. We care about it, we study about it, and we try to be as propositive and as engaged as possible. So I think that those alternative ways of setting boundaries are always welcome, but states try to stay with the ones they know. So it is nice, and it is healthy, I think, to think of other methods, but you usually bring to the table what the court would do, and that makes a lot of sense, because if negotiations fail, and you're going to the court, you sort of want to scare the other one away and say, you're going to lose in court. But I think that what you're saying is true. It's not. I don't think there is a very thorough job done on which are those creative or more different alternatives to setting up boundaries, and we probably have to learn from those more creative alternatives. But in general, states try to stay safe, and that's good or bad. But at the same time, what has implied in practice is that it's very special, and it's very much related to the bilateral relationship when states enter into more creative mechanisms. In general, everybody goes the safe and known path. So I think we have to do a better job at identifying those other ways of setting up the boundaries and then bringing those to the table. But so far, I have not seen that as very common in general when negotiating these agreements.
Thank you, Lucia. Next, I have a question from Francesco Gaudiosi, who wants to know whether you think that judgments on maritime delimitation in enclosed or semi-enclosed seas might be surprising for concerned states, notwithstanding the well-consolidated case law in this field.
Yes and no. I mean, what I can say for sure is that, especially through adjudication, sometimes the fact that you are within an enclosed or semi-enclosed sea is not very much taken into account by international courts and tribunals. I mean, everybody knows what it means to be within an enclosed or semi-enclosed sea, but then in practice, it doesn't have such a strong impact. And when I say this, again, I'm trying to be as careful as I can here. I don't want to lose my job, but the court or the courts sometimes issue some judgments which don't take into consideration the effect that a limitation can have on other agreements which are in place. So what I would say for sure is that that has to be better assessed, because evidently, with courts, when they are deciding a case, they are focused about the two states that are having, two or more states that are having the controversy and on setting, the line between them. But that line can really have, a sort of a effect on other lines, especially if you are so close together. So without being too critical of the court, I think, or the courts, and I usually say the court because in Latin America it's mostly the ICJ, but sometimes the courts have to be more careful about the consequences of their judgments, the effects those might have, especially when you're so close together and when there are already delimitation agreements in place. I think we're going to have problems in the future, we Colombia, because some of our agreements depend on other agreements, and we have to check whether those are affected by other delimitations that the courts have issued or agreements entered into other states. But I think that effect it has to be better assessed by the courts and when issuing their delimitation judgments.
Thank you, Lucia. And the next, there are some common themes in the questions, so I want to raise this, and especially because it's such a topical issue right now. I have questions from Marcelo Molina and Reese Lewis about sea level rise, where they would like to ask you what sort of impact do you think sea level rise will have on the future of negotiation of boundary agreements, and whether do you have any experience with this? Are there any resilient measures now being built into the agreements? And do you feel that there's going to be a greater need in the future to revisit these agreements?
I think this is an area of the law that is in the making. Everybody's studying about it. most states of the world have not decided on what their stance is going to be on sea level rise. Some have, and some have been very active, especially the Pacific Island states, for example, and they know what they want, and they know their position vis-a-vis the sea level rise. But most of the states of the world don't have a position yet. There are many. Many is an exaggeration. There are several options. So some states might be interested in revisiting the agreements, right? Reopening all of the agreements and setting new boundaries if those are affected by sea level rise. I think those are few probably, but I don't know, because not everybody has already issued their position or explained their position. Some other states are thinking about starting to build artificial islands or some other ways to adapt to sea level rise. States like the Netherlands are thinking about that. How do they face sea level rise? And they are experts at dealing with water, and so they are thinking about how do I stop this, or what measures can I take for at least not getting completely drowned. But other states, and I think those probably are going to be the majority of states, are saying, if we start to take into account the sea level rise and how those affect our lines, things are going to get very complicated, because a lot of agreements are going to change, because they come from baselines that are going to change with sea level rise in practice. So does that mean now all of the agreements are going to be reviewed and amended and so on? Again, I don't know. Colombia has no position so far, and many states don't have a position and are in the process of building that position. Some don't have the knowledge to reach a position, and they might need help in that regard. But what I can say for now is that it is going to have an effect in practice on the lines. How that effect translates into the agreements, it's a more open matter, because nobody knows what's going to happen, and if the general agreement of states, it's going to be, let's leave things as they are, let's not touch the agreements because it's going to be mayhem, or let's reopen every single agreement and let's see if I can gain anything from renegotiating the agreements. It's really very much up in the air right now, but I think states are thinking about this slowly sometimes, and again, we might need help. But so far, the measures and the agreements and the sort of discussions are very, very in a very initial stage.
Thank you, Lucia. I have an anonymous question for you. What are your views on the recent phenomenon of taking cases from UNCLOS Annex 7 tribunals to permanent judicial bodies, like, for example, Mauritius, Maldives, in terms of cost effectiveness, efficiency, and having a pre-established institutional and procedural framework?
Well, first of all, I think I'm not the right person to ask this question, because as Colombia is not a state party to the Law of the Sea Convention, we really have nothing to say about other tribunals that are not the ICJ, with which we are very much engaged. But having said that, I think that states in general, they choose what they think is the best avenue for their interests. So they check the jurisprudence, they check the other cases currently being litigated, and they decide which tribunal can be better for me. Or sometimes they only have one avenue because they chose one when they join the convention, or because the other ones are closed for many reasons. So sometimes states can choose, and sometimes it's just what you have available. So the best you can do is go through an Annex 7 tribunal or whatever. So I wouldn't like to be too categorical about this, because again, I don't have an expertise or experience in this regard. But I think more generally, what states do is try to find what's the best way to accomplish or to reach the line that I want. And then you choose the tribunal, if you can choose. So I'm not evidently not against it or for it. I just think it's it's what it is and it's what international law permits. Now, sometimes those tribunals issue decisions that are at odds with decisions of other tribunals. But I guess that's true in any area of the law, and at the same time, it gives us quite a lot of work to us lawyers. So it's a fact, it's a reality, and states have to deal with it the best they can.
Thank you, Lucia. So we've arrived on the dot for the end of our session. Would you be up for another question, or would you?
I can, yes, if you want, if you can.
Okay. Why don't we conclude with a final question, and perhaps this is something also quite maybe also a nice angle to think about. The question I'd like to conclude is that, I would like to ask you, what are your views about whether there could be some room for perhaps more conciliatory means to be used by states in the future? So when when other options are available, such as mediation or conciliation, and given the time, cost, and complexities of dispute settlement and the increasing legal certainty as to the rules governing maritime delimitation, do you think perhaps in the future there's room for more conciliatory means to be used by states?
I think that is a great question, because it's looking to the future. As I said before, states are very open to options in general when things are not going well. When a limitation agreement is going well and you reach it, that's fine, that's perfect, that's the preferred way. But sometimes things can get complicated, and when things get complicated and your only option is going to court, well, that can help in the negotiation, because if your alternative is going to court, then you rather negotiate well. But there are many intermediate options, and states almost never think of those. It's just like you have to choose whether negotiate or go to court. And I think we should be better at getting creative there, because sometimes negotiations can reach a stalemate, and you just don't know what to do. Or what happens, as I told you before, in the case of Colombia and Venezuela, is okay, you reach the agreement, but the agreement, it's impossible to get approved domestically. So the problem is not the agreement as such, but having your people in your country understand how this is the best agreement you could reach, but if it is. So there are many alternatives to having agreements. And when the agreement is impossible, when the political situation doesn't allow even to sit and talk, you can have a third person come and sort of help in finding creative ways, or you can propose these non-adversarial mechanisms that can also be very, very useful. So I'm very, very open for that. I don't know if states are. I think that states just never consider the possibility of those agreements, and somebody has to, sort of suggest those. So it is our job as government officials to suggest them. We never know or study those as thoroughly as we study the jurisprudence, for example. So maybe the way forward is to think about these mechanisms and see what can we do when agreement is not possible, which agreement remains evidently the best or the preferred way by states.
Thank you, Lucia. And before we conclude, I want to point out not a question, but a promotion by Judge Lisbeth Leinzad, who would like to draw attention to Irini's very good book, Gender and the Law of the Sea. So that's fits very much with our theme. But thank you so much for taking the time to join us today and to share your experience from the negotiating table and all over, and also to bring a little bit of the Latin American perspective to our series here at Essex Law School. Thank you so much for this very engaging and exciting fireside chat.
Thank you. Thank you for having me. It was a lot of fun.
Thank you. And for if Dr. Jones, if you want to say a few words at the end.
Yeah, it's just to thank you both. That was a really interesting fireside chat and really great to hear from your experience, Lucia. So thank you so much. And just to remind everyone that at this time next week, we have Professor Marty Koskinemi. So do tune in for that one as well if you're interested. But thank you very much, everyone, for joining us. And thanks, Lucia.
Thank you.